Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're continuing with our ongoing series entitled AOE-COE, Industrial Causation. And today we're going to be concluding this series, and I have a fascinating discussion that will apply to each and every qualified medical evaluator in the entire state of California, regardless of specialty. This is an absolutely critical discussion for every one of us, and we'll conclude our series today with that discussion. Now, before we get to today's material, I just want to review some of the discussions that we've had so far in this series, and then simply provide you with the most important of the most important principles from each one of those discussions. So in this series, we began with a discussion entitled The Argument For or the Argument Against Industrial Causation. Now, it's important to remember that the AOE-COE determination is only important in those cases of yours that have been delayed or denied. It's not necessary in the cases where the case has been accepted, where the examinee has already gone through medical treatment and is now permanent and stationary and needs your opinion to close the case. On the contrary, these cases involve your opinion at the beginning. They require your opinion at the beginning of the case. These are cases that have been delayed or denied, and the claims administrator simply wants to know one thing, and that is this claim compensable? It's called the compensability exam. So your AOE-COE determination is only necessary in a limited number of your cases, the cases that have been delayed or denied. But I submit to you that even though it's not every one of your cases, it comprises the bulk of your cases that you're going to be getting. These comprise the bulk of the cases that you're going to be getting. So you need to be able to recognize those evaluations that involve a delayed or denied claim. So once you can do that, in our next discussion we talked about the philosophy of a denied claim. We talked about the reasons why the claims administrator would deny a claim in the first place. Why would a claims administrator deny a claim, and why would the claims administrator accept a claim? What's the difference between the two claims? Well, the difference between the two claims lies largely in the presence of red flags. Red flags. It's red flags that cause the claims examiner to dispute the authenticity or the veracity or the compensability of the claim. So we talked about some of the many red flags. And as qualified medical evaluators, we need to be aware of these red flags going into our evaluation so that we can orient the perspective and the direction of our evaluation and our examination. Then in our third discussion, we talked about the role of the qualified medical evaluator in this so-called Labor Code 4060 compensability exam. Many qualified medical evaluators don't understand their unique role in these evaluations, which is much different than their role in evaluations under different labor codes, such as Labor Code 4061 and 4062, which involve disputes over permanent and stationary, permanent impairment, apportionment, etc. Those opinions are required at the end of the claim. So for these Labor Code 4060 compensability exams, the qualified medical evaluator has a different role and a unique role and a highly specialized role, the end result of which is to provide an opinion and conclusion on AOE and COE. In our next discussion, we talked about the burden of proof, and we said that Labor Code 3600 requires that the examinee, the employee, prove industrial injury. See, claims become denied when the claims administrator realizes and recognizes and knows that the employee cannot prove their claim. Those are the claims that become denied. Now, the burden of proof is on the employee. many qualified medical evaluators incorrectly and unnecessarily assume the burden for the applicant. And I want to encourage you to stop doing that. Stop doing that. It's not your role to assume the burden of proof. That lies squarely and legally on the shoulders of the employee. Okay? In our next discussion, we talked about the obsession with cumulative trauma claims, and we talked about all the reasons why you're getting evaluations that involve multiple dates of injury, one of which or more consist of a claim for cumulative trauma injury. So it seems that cumulative trauma injuries are at least a component of or are tacked onto every single evaluation that we're doing. We talked about why that is, and we talked about how to handle it. And in our last discussion, we had 3 cases that we reviewed, and the purpose of the 3 cases was to illustrate the thought process and the handling and the decision-making process involved in the AOE-COE determination in 3 actual cases. And it was interesting because in 2 of the cases, either myself or another QME doctor opined for FOR, industrial causation, so that was a very employee or applicant-oriented approach, you might say. And then in one of the cases, we opined against industrial injury, so you could say that that was employer or defense-oriented opinion. And so we gave you an example of the AOE-COE determination in both directions. Okay, so it's been a fascinating discussion up till now, and I'm sure you'll agree with me that this discussion on causation is a complete course on industrial causation. You know, like you, I've been to many weekend seminars and training courses for qualified medical evaluators, and during those courses, one or more speakers may address multiple topics. And on the topic of industrial causation, if it's discussed at all, you might get at most 30 minutes to 45 minutes to maybe at most an hour discussion, because there's other speakers as well. And so qualified medical evaluators are untrained in the critical thinking involved with the AOE-COE determination. So this is a complete course on industrial causation, more complete than you can find anywhere. I challenge you to find a more comprehensive discussion of causation than this. I don't believe you will. Now, in today's discussion, we want to conclude with a critical topic, and it has to do with causation in a way, as the causation discussion and the causation determination and the causation section of our report applies to the complexity factors involved in billing your report, either under an ML103 or ML104 billing level under CCR 9795. So a discussion of causation in its many forms, of which AOE-COE is one of the forms. It's not the only discussion of causation that we do in our reports, but it's the principal one, and it's one of the many forms. Okay? So, in our QME reports, we have a section in our report entitled Causation. And in the denied or delayed claim, which is the focus of this discussion, the causation section of the report is the critical section. It's the definitive section. It's the end-all, be-all section. It's the first section of the report that the reader of the report, which is the claims administrator or perhaps a defense attorney, it's the first section they're going to go to find out what's your conclusion. Is it for or is it against industrial injury? So under CCR 9795, causation, because of the difficult and complex decision making involved in coming up with an AOE-COE determination, the law, CCR 9795, provides for a complexity factor for a discussion of causation. So if you use causation as a complexity factor in your QME report, it should follow certain criteria in order to fully qualify as that complexity factor under CCR 9795. And in reviewing hundreds and hundreds of QME reports, I find that QMEs improperly and erroneously use causation as a complexity factor under ML103 and ML104, and that's a problem. We don't want any problems, and so the purpose of this discussion is to make sure that we're all on the same page as to what qualifies causation as a complexity factor under 9795, and how to properly use the complexity factor and how to properly document the necessity of the use of causation as a complexity factor in your report, so that your report can be properly paid and never criticized for any reason whatsoever. So I'm going to share with you a tried and true approach to handling the causation section of your report, so that that section of your report qualifies as a complexity factor in the ML103 and ML104 billing levels. So in order to illustrate these principles and the ideas involved, we're going to go to the computer and have a screen share wherein I can show you how to handle the complexity factors and how to handle the causation section of your report, so that the two coincide and qualify as the complexity factor that is described under CCR 9795. So I look forward to being back with you here in just a few minutes, and we'll meet at the computer as we continue today's discussion on AOE-COE, the causation as a complexity factor. Hi, this is Dr. Perry Carpenter. Thanks for joining me again. We're continuing our discussion on causation as a complexity factor. And just to review, there's just a few key points that I want to share with you in this discussion. First of all, I want to review CCR 9795 as it relates to the causation and the formal description of causation as a complexity factor. Then I want to show you how to prepare the causation section of your report to adequately discuss issues related to causation, and specifically AOE, COE, industrial causation. And then I want to show you how to prepare your discussion of causation as a complexity factor in the beginning section of your report, wherein you report all the times involved with your evaluation and your billing level, whether it be ML103 or ML104 that you're using for this evaluation. So let's begin now by taking a quick look at CCR 9795, and we'll take it from there. Okay, so here we are. We're at the computer, and I have up on the screen CCR 9795. This is off the dir.ca.gov website. And let's review causation as a complexity factor. So many of you are familiar with this, this section of the QME regulations and this table that describes the use of the complexity factors. But let's go down to the ML103 right here, and below it the ML104. This is where it talks about causation as a complexity factor. That's listed right here under the 6th complexity factor. But before we get to that, let's go over the requirements for the use of ML103 and the ML104. And I want to read for you this paragraph right here. It says, in a separate section at the beginning of the report, the physician shall clearly and concisely specify which of the following complexity factors were required for the evaluation, and this is equally important, the circumstances which made these complexity factors applicable to the evaluation. Okay, so we have to clearly and concisely specify two things: which complexity factors and why they were applicable to the evaluation. So let's keep that in mind when we go back to our QME template or our QME report and report on causation. Okay? So with that established, let's review now this causation as a complexity factor. It says addressing the issue of medical causation, comma, upon written request of the party or parties requesting the report, semicolon. Now, this description here used to go on beyond the semicolon. It used to say, after the semicolon, it would say, quote, or, comma, if a bona fide issue of medical causation is discovered in the evaluation. So this description of the complexity factor has been shortened, and the part that gave authority to the evaluator, the QME evaluator, gave the authority to invoke causation as a complexity factor by describing a bona fide issue of causation that surfaced during the evaluation. This complexity factor used to provide the doctor with that authority. Now, this has been shortened, and that has taken away the opportunity for the qualified medical evaluator to use causation as a complexity factor. Now, causation can only be used as a complexity factor upon written request of the party or the parties requesting the report. So you need to have a written request from the parties to address causation in order for you to address causation such that it qualifies as a complexity factor under CCR 9795. So you need to become expert in identifying the causation questions that come from the cover letters from either the claims examiner or from the attorneys on both sides. You need to comb through those cover letters to extract the causation questions, and then you need to do a fabulous, fabulous, fabulous job in answering those causation questions, and we'll go over just how to do that in just a moment. But let's go to some cover letters and see if we can pick out the requests for discussion of causation. So let's go to this cover letter here, and you may recognize the layout of this cover letter, but all names, of course, have been redacted. In any event, here's the cover letter with the information removed, and it gives some background as to the claim. It talks about some questions related to causation. For example, it says here, if you find a specific and accumulative trauma injury applicable, please indicate why and support your findings. Would you agree with me that that's a causation question? That is a causation question. And let's continue. This cover letter contains many causation questions. So there's one right there. It says here, please address the following in your report. And here comes the questions. It says a detailed medical and employment history, including outside activities. That's probably not a causation question. How about this one? What is the diagnosis? And please describe the medical basis for your opinion as to the diagnosis. Well, that could be conceived as a causation question. That could be conceived or perceived, but there are other ones that better qualify. How about this one? Are your medical findings consistent with the mechanism of injury alleged by Casey Johnson? In other words, is it possible that the mechanism of injury that was described by this applicant could have caused the medical findings on evaluation? Or are those medical findings not caused by the alleged incident? In other words, is the mechanism of injury not consistent? That is a causation question. And I want you to remember this question because we're going to see this question returning up as we fashion our causation argument. Okay? So let's look at another cover letter. Here's another cover letter with the information removed. or the identifying information removed. And again, it gives some background information here. This is obviously from an applicant attorney because he says, I filed a cumulative trauma injury alleging injury AOE-COE. So there's definitely something that we're going to need to address, the cumulative trauma injury, and whether or not the symptoms related to that qualify as an industrial injury. So keep your eye on that. And then the applicant attorney comes right out with a direct request for a discussion of causation. He says, please render an opinion to a reasonable medical probability on the following issues. And here he directly comes right out and says, he says, is the disability caused by, contributed by, or aggravated by the injury or illness, injury or injuries alleged in the application? So there is your direct request to address causation. This is what you need in order to employ causation as a complexity factor. It needs to come by written request from the party or parties requesting the report. Let me show you a couple more. Here's another cover letter. I have all the identifying information blocked out, but again, it gives some identifying information. Talks about injury to the low back and the arm. It says here that the claim has been denied by the defendant. The claim has been denied. So this is going to be one of those evaluations that we do under Labor Code 4060, the compensability exam. So this exactly applies to every bit of the discussions that we've had so far related to denied claims. So you can bet that questions of AOE-COE are going to be critical in this evaluation. And let's just go to it. It says here, please address the usual panel QME questions, including please address causation as it applies to applicants' claims in above manner. So that directly asks for a discussion of causation. And let's go to our very last cover letter. Again, some information and some background information. And then it says here the additional injuries have been denied. So AOE-COE is obviously a prevailing issue in this report. And it says, please provide your diagnosis and describe all impairments and address work-relatedness. Work-relatedness, that's causation, correct? Work-relatedness, causation, and other issues. And herein is your specific authority now to go ahead and address causation and to report causation as a complexity factor in your report. So let's now go to our report, and let me show you how it is that you report on causation in your report, both in the separate section at the beginning of your report and then also later on in your report where you provide your opinion for AOE and COE. So here's our QME template. And remember, we're supposed to provide in a separate section in the beginning of the report our description of our complexity factors. So here it is. This is on page 4 of the report, which basically becomes page 1 or page 2 once all of this working portions of the template are removed. But you can see here, we put our date here, we address our report here, the patient or the examinee demographic data goes here, and then we get right into our description of the complexity factors. So here it says, in compliance with Title 8 CCR 9795, this report is being submitted as a comprehensive medical legal evaluation involving the following complexity factors. And complexity factor number 5 is addressing the issue of medical causation upon written request of the party or parties requesting the report. Now, to do this properly, you need to now cite the circumstances. Remember, CCR 9795 said we had to cite the circumstances, which makes this discussion applicable to the report. So let me show you how to do that. You simply indicate that the February 2nd, 2017 cover letter from Betty Lou of ABC Law Firm requests, and then put down their specific request that Betty Lou asked of you in her cover letter. So here we just reviewed 4 cover letters and I've pasted in the requests for causation from those cover letters. So this includes all 4 of them. But remember, one cover letter said, please address causation as it applies to applicants' claims. Another one said, please provide your diagnosis and describe all impairments and address work-relatedness and causation. Another one asked for a specific discussion of causation. And the third one asked if you find specific and CT applicable, please indicate why. It asked for the medical findings consistent with the mechanism of injury. And those are all the specific written requests that you received to address causation. And this is how you set up your complexity factors to explain the need for causation as a complexity factor. And then you want to refer the reader to the specific section of your report wherein they will find your discussion of causation. So you send the reader then to page 37 to see your discussion of causation. So let's now go to page 37. We'll talk about how to do the causation section of your report. Okay, so here we are. We're at the causation section of our report, which is right here. Here's the causation section. Now notice I simply cut and pasted the whole description from earlier on right here in the causation section of the report. Remember, these were all the questions that were being sent to us in written form requesting a discussion of causation. And we had the date and we had the name of the claims administrator who asked for the discussion of causation. If you have many cover letters, you would simply provide this sentence for each of the cover letters. So you might have multiple cover letters down here below. I simply extracted all the questions just to make it convenient here. So here's all your questions requesting causation. Well, it's in this section of your report that you then are charged with the responsibility of providing an opinion either for industrial injury or an opinion against industrial injury. Now, to make this difficult decision, you simply make a Ben Franklin list. And here I have a table arranged in 2 columns with a line down the middle. This is the Ben Franklin list. Now, in this column, you're going to provide all the reasons as to why you opine or why you could opine or why you do opine for an industrial injury. And in this column here, you provide all the reasons why you opine against an industrial injury. And then you simply provide your opinion for or against industrial injury based upon the column that has the more voluminous and the more compelling reasons. So for an opinion for industrial injury, this chart needs to be chock full of data, facts, dates, medical records, objective data that support an opinion for an industrial injury. If you opine against industrial injury, this side of the column needs to be similarly packed with objective supportive data. And then you simply opine based upon the column that has the more voluminous and the more compelling reasons. Okay, once you come up with your opinion, then you simply answer the question. And you answer the question in the following manner in order for your opinion to qualify as a complexity factor. Now remember, the parties are looking for specific answers to these questions. So basically the question is, there exists a dispute over the compensability. Is there an industrial injury? And your answer might be yes, and it might be no. So let's handle how a yes answer might look and how you might format your opinions and conclusions. So the answer is yes. In my opinion, and within reasonable medical probability, the current symptoms described by Mrs. Smith involving the cervical spine, the right shoulder, and the left knee are due to the industrial of 1-1-15. Reasons for this conclusion include, and now here's all your reasons. And your reasons simply are taken from your Ben Franklin table above. So some of your reasons for an industrial injury might be that it was a witnessed incident. Some of your reasons for could be that there was immediate reporting of the injury. Some of your reasons against an industrial injury might be that it was an unwitnessed incident and that there was a delay in reporting. And whatever. But in your description below, you might do something like this. Reasons for this conclusion include witnessed incident. The injury involved a fall in the courtyard of the restaurant where Mrs. Smith is a cook. The injury was witnessed by the owner of the restaurant, who has provided a written statement of his observations, something like that, and that it was immediately reported, and that she had immediate onset of symptoms, and then when she got to the emergency room, she was diagnosed with a bona fide condition, and etc., etc., etc. The more reasons and the more compelling are your reasons, the more irrefutable is your opinion for FOR, an industrial injury. Now you might opine that because this side of the table over here is so compelling and so voluminous, you might opine against an industrial injury. So you would fashion your answer and your argument as follows. Answer: no, in my opinion and within reasonable medical probability, the current symptoms described by Mrs. Smith involving the cervical spine, the right shoulder, and the left knee are not due to an industrial injury of 1-1-15. Reasons for this conclusion include that it was an unwitnessed incident, and give your description here. That there was a delay in reporting, and give your description here. Delayed onset of symptoms, give your description. Examination, etc., 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 etc. And the more reasons and the more compelling reasons that you have to opine against an industrial injury, the more irrefutable will your opinion on AOE-COE ultimately be. It will basically be irrefutable. The more reasons and the more compelling are those reasons, the more irrefutable becomes your final opinion and conclusion. Okay, doctor, so can you see the integratedness of this procedure? So let's review this, and let's review the key components. CCR 9795 requires us to do two things. In a separate section at the beginning of our report, if we use causation as a complexity factor, we're required to so state that in a separate section at the beginning of our report. And I showed you how to do that in the template. It also requires that we then describe the necessity or the circumstances that required the use of that as a complexity factor. And in this case, it's the cover letters that we receive from the parties that give us the authority to investigate, to report on, and then to apply causation as a complexity factor. That comes from the cover letters. So in the separate section of your report, you describe the cover letters in explaining the circumstance which required causation as a complexity factor. Then, once you establish your authority to discuss causation and to bill for it under ML103 and ML104, you refer the reader to the causation section of your report. Now, because causation, like review of records, is one of the complexity factors, if you're billing for causation as a complexity factor under ML103 and ML104 in your report, then let me tell you this. The causation section of your report, if you're billing for it, should be a masterpiece. It should be a masterpiece. It should be one of the focal points of your report. It should be one of the sections of your report upon which you give your greatest attention, your greatest decision making, your greatest critical thinking skills. It should be a masterpiece, and it should be elaborate, and it should be impeccable. It should be formatted perfectly, and your reasons, your list of reasons in support of your opinion should be irrefutable. They should be based on facts, key data, objective findings, specific dates. It should all be irrefutable. Irrefutable. Now, when you get to the causation section of your report, okay, so let's go there now. In the causation section of your report, you reiterate your authority or the circumstance which required a discussion of causation in this report. Again, that comes from the cover letter, and you simply cut and paste from the separate section at the beginning of your report into later into the causation section of the report. You simply cut and paste that to reestablish your authority, okay? And then you provide your answer in yes or no format. Remember, for these compensability exams, the question is simply, yes, this claim is compensable, or the question and answer is no, this claim is not compensable. Claims administrator simply wants to know yes or no. So provide your answer, yes or no, and follow that answer up with your reasons why you opine such. So that would be phrased as follows. Yes, in my opinion, within reasonable medical probability, the symptoms that Mrs. Smith is reporting is directly related to the 1/1/2016 industrial injury, period. Reasons for this conclusion include colon, and then give a bullet point list of all the reasons that support your opinion for an industrial injury, or if you're opining against an industrial injury, provide all your reasons as to why you opine against an industrial injury. And let me tell you this, make your reasons good. They better be good. They better not be wimpy. They better not be speculative, based on guessing or based on conjecture. See, we can't do that. The AOE COE opinion has to be based on objective facts, findings, key data, dates, specific, factual data, and make it good. And finally, the more voluminous and the more compelling reasons that you can provide either for or against industrial injury makes your opinion more or less irrefutable. Now, if you follow this procedure exactly every single case, in cases where complexity is specifically, where causation is specifically requested by the parties, your causation discussion and your causation section of your report will qualify as a complexity factor under CCR 9795, and no party, no payer will have any objection to fully paying for the ML103 or ML104 billing level that you're billing for, because you've adequately, expertly, and elaborately done a fabulous job on the causation discussion in your report. So doctors, I hope this helps you. This is a critical piece of information, both to make sure that you get paid for what it is you're doing and to make sure that you don't get into any trouble and that you don't bill for procedures that you don't do. Okay? So I hope this helps you, and it's been my pleasure to be with you here today on this video. Look forward to being with you on our very next video. And for now, this is Dr. Perry Carpenter. I'm wishing you the best success in your career as a qualified medical